S. Chan presents educational video lectures as per the new UGC curriculum. Difficult concepts made easy. Study anywhere, anytime.
A company promises to pay an employee a monthly salary in exchange for their work and services. The salary provided by the company and the work performed by the employee represents the consideration exchanged. What is that consideration? Let us have a look into it. What is that consideration? The number one, services from employee, and the number two, money from the employer. And these two people are forming a valid agreement.
If you want to study this topic in detail, refer to the book by S. Chan Publishing and Vikas Publishing House. Link is provided in the description box.
Welcome to S. Chan Academy. My name is Mohit Kapil, and today we are here to discuss about another topic, and that is consideration. Let me tell you guys, the consideration is also one of the essentials of a valid contract, and this is really very important to form a valid contract. Let us look at the video. So this is our first slide. This was an example, this was the case study through which you can understand what is consideration. Consideration here means a service or a money. So what is consideration here? The consideration, the first consideration is service from employee to the company and money from employer in exchange of those services. So what is consideration here? Something which is exchanged between the contracting parties. So in order to understand this particular term, let us have another slide and let us understand what is the actual meaning of consideration. Consideration is the requisites of a valid contract, a promise or a set of promises, or in other words, a promise or a set of promises which is made without consideration is absolutely void, and that leads to a void contract. So in order to have a valid contract, consideration is one of the essentials or one of the important requisites of a valid contract. In other terms, in contract, both the parties enter into a contract to give something to each other. This is one of the important fundamental. Whenever we comes into a commercial transaction, we always need something in return, and that something is always known as consideration. So in a contract, both the parties enters into a contract to give something to each other, which is known as consideration in a legal sense. So in this particular slide, we had a meaning regarding the term, that is consideration. In this particular next slide, we will understand what are the essentials required to form a valid consideration. I hope you must have understood till now what is consideration, and now in this particular slide we'll talk about the essentials of a valid. What are the essential things which are required to form a valid consideration? Okay, let us talk the first point here. There must be some legal value in the form of consideration, in the form of something which will be exchanging between the two parties, that would benefit both the parties to form a valid contract. Number two, there must be a mutual exchange of something between the contracting parties, those who are involved in it, in order to form a valid consideration. Let me highlight something here. Let me emphasize something which is very important. In order to have a valid consideration, there must be a mutual exchange of something between the contracting parties, those who are doing a commercial transaction between them. Number three, consideration. Very important. Consideration, again I am telling you what is the meaning of consideration. Consideration means something which we are going to exchange in terms of something. Like for example, मैंने किसी से ब्रेड खरीदा एंड आपने उसको पैसे दे दिया, राइट? आपने ब्रेड खरीदा और आपने उनसे ब्रेड लिया और आपने उनको पैसा दे दिया, तो आपको मिला ब्रेड, उनको मिला पैसा. वो क्या हुआ? एक्सचेंज किया, और एक्सचेंज ही हम यहां पर कंसिडरेशन बोल रहे हैं, जो वैलिड होना चाहिए. इनवैलिड कंसिडरेशन क्या होता है वो हम डेफिनेटली नेक्स्ट स्लाइड में समझेंगे, बट यस, इन दिस पर्टिकुलर स्लाइड वी विल बी अंडरस्टैंडिंग द essentials which are required to form a valid consideration. So there must be mutual exchange of something between the contracting parties, those who are involved in it. Number third, consideration may be a real value, not any illusory, and that can be given at the time of contract, either in the present time or in the future time. Next point, which is the very important point, both the parties should have legal and positive intentions. We are on continuously talking about, intentions since the beginning of the, this particular subject. Both the parties should have legal and positive intentions to form a valid consideration. Number last point, but this is absolutely not the least point here. And what is that? Number last point, but not the least point. And what is that? Consideration either have already performed, which is known as executed, or yet to be performed, which is known as executory at the time of formation of the contract. So these are the essentials which are absolutely required to form a valid contract. What is the number one? There must be some legal value. What is the number two? There should be mutual exchange between the parties. Number three, there must be a real value and it should not be illusionary. Number fourth, both the parties should have a legal and positive intentions. And number fifth is either it should be executed or executory. I hope this particular slide is clear to you. In order to have more clarity about consideration, let us understand the other slide. Now, this slide will let you know the exceptions. ऐसी क्या चीजें हैं जिसके बेसिस पे हम ना तो consideration create कर सकते हैं ना ही contract create कर सकते हैं. What are those things? Let us understand. There are three different conditions, though there are a number of conditions, but yes, there are three specific conditions which I am referring here so that you can understand what are the situations where the exceptions are lying to the rule of no consideration and no contract. Number one, expressed, if a contract is expressed in writing, any agreement which is expressed in writing and a register agreement came out of any affection. अगर कहीं पर आपको कोई लगाव है या किसी से प्रेम हो गया है between both the parties, those who are standing near relationship to one another, that leads to no consideration and no contract. प्लीज मेक अ नोट ऑफ इट. ज्यादा एम्फेसाइज करने की कोई जरूरत नहीं है. यू बेटर अंडरस्टैंड द पॉइंट, क्योंकि हम लोग कॉन्ट्रैक्ट करते हैं इन ऑर्डर टू हैव बिजनेस ट्रांजैक्शंस, इन ऑर्डर टू हैव कमर्शियल ट्रांजैक्शंस. बट लेकिन जहां पर भी साइकोलॉजिकल सेटिस्फैक्शन क्रिएट हो रहा है या कोई इस तरीके का सेटिस्फैक्शन क्रिएट हो रहा है, जैसे फॉर एग्जाम्पल इफ यू आर एग्रीइंग और इफ यू आर राइटिंग समथिंग in because of affection, because of love between both the parties, those who are standing in near your relationship, that forms no consideration. I mean, that leads to no consideration and no contract. Number 2 point, if someone has been working voluntarily for you, or someone has re-rendered his services voluntarily, then there will be no consideration. मैं अपनी इच्छा से आ रहा हूं आपके पास काम करने के लिए. If someone is coming by his own wish, then I mean this particular rule is not applicable as per the law. Number 3rd, written and registered promise by the debtor to pay a timed bad debt. Let me tell you this particular statement, ये हमें समझ में आएगा with the help of an example. मान के चलते it means a person who has borrowed money and did not repay, which is no longer legally collectible as per the law. आपने एक समय पैसा लिया किसी से, उधार लिया, बट लेकिन एक पर्टिकुलर टाइम पीरियड में आप उसको नहीं पे कर पाए या कलेक्टिवली आप उसको रीपे नहीं कर पाए, तो ऐसे केस में क्या होता है? लेट अस अंडरस्टैंड. रिटन एंड रजिस्टर्ड प्रॉमिस बाय द डेटर टू पे ए टाइम्ड बैड डेब्ट. It means a person borrowed a money and did not repay, which is no longer legally collectible. I repeat, a money and did not repay, which is no longer legally collectible, caused by a certain number of years past. आपने पैसा लेना था, टाइम भी निकल गया, आप भूल भी गए, उस पर्टिकुलर केस में क्या होता है? That leads to no consideration. क्योंकि एक टाइम पीरियड होता है, उस टाइम पीरियड के अंदर अगर आप अपना रीपे नहीं कर पाए या सामने वाला आपसे कलेक्ट नहीं कर पाया, तो वो लीगली कलेक्टेबल फॉर्म में नहीं रह पाया, जिसकी वजह से अगेन नो कंसीडरेशन एंड नो कॉन्ट्रैक्ट क्रिएट हो गया. बिकॉज उस कॉन्ट्रैक्ट की कुछ टर्म्स थी, उसकी कंडीशंस थी. अ टाइम फ्रेम बहुत इंपॉर्टेंट रोल प्ले करता है. इफ द टाइम हैज बीन पास्ड, इफ द सर्टेन नंबर ऑफ ईयर्स हैज बीन पास्ड, देन दैट लीड्स टू नो कंसीडरेशन. आई होप दिस पर्टिकुलर स्लाइड इज क्लियर टू यू. सो इन दिस पर्टिकुलर स्लाइड वी वर डिस्कसिंग अबाउट what are the exceptions available to no consideration and no contract. Number 1, affection and love between both the parties, that leads to no consideration. Number 2, if someone is working as a voluntarily to you or by his own wish, then again no consideration. And number 3rd point is a written and registered promise by the debtor to pay a time barred debt, but a certain number of years passed and that becomes no longer legally collectible, so there would be no consideration. Let us understand the next slide. Now this is the question time here. Let us have a question which is very important in order to understand this particular topic, that is consideration. And let me tell you, I always say in the video कि ये questions आपकी understanding के साथ साथ आपके exam को prepare करने में भी help करते हैं, and these questions help you to know कि मैंने बीच में क्या पढ़ा. Number one and the number last only, identify the essential requirement to form or for a valid consideration in a contract. आपको इन चार options में से एक ऐसा सही option identify करना है that will help you to let you know, yes, this particular option is essential requirement to form a valid contract. So in order to get the answer of this question, please stay connected with us, please stay connected with S-Chand. S-Chand is always there to help you.
Now quality learning is easily available at your doorstep. S-Chand Academy brings detailed lectures based on UGC curriculum as per the New Education Policy 2020. So do not forget to subscribe to the S-Chand Academy and access the wide world of knowledge conveniently sitting within the comfort of your home. Stay connected and keep watching S-Chand Academy. Happy learning!
So welcome to S-Chand Academy. My name is Mohit Kapil. Before break, we were talking about the very important topic, and that is consideration. So till now, before break, we have discussed about the meaning of consideration. We started, this particular topic with a case study related to that particular topic. And then afterward, we had a discussion regarding the essentials required to form a valid consideration. And after that, I give you a question. In order to stay with that, in order to get the answer of that question, stay connected with me. So let us move to the next slide so that we can understand this particular topic more clearly. Okay. So now I'll talk about the legality of objects. If two people are involved or engaged in any drug trafficking, that would definitely lead to an illegal object, because the agreement between them violates the drug laws and public policies. So apart, such contracts are always unenforceable by law. यानी कि कानून की इजाजत ही नहीं है हमें इस पर्टिकुलर चीज को डील करने की. सो अपार्ट सच कॉन्ट्रैक्ट्स आर एनफोर्सेबल बाय लॉ, एंड व्हाट डू वी कॉल दीज कॉन्ट्रैक्ट्स? void contracts. I hope void agreements भी बोलते हैं, void contracts and void agreements. I hope this particular example is clear to you so that you can understand what we are talking about, why we are talking about the legality of the objects. Okay. On the other hand, a contract for the sale of any goods or service in accordance of the laws would have a legal object. अगर हम बात कर रहे हैं किसी भी एक ऐसे सेल ऑफ गुड्स की, सर्विसेज की, जो कि एब्सोल्युटली लॉज के अकॉर्डिंग है, एज पर द लॉ है, सच कॉन्ट्रैक्ट्स मेकिंग इट वैलिड एंड ऑलवेज दीज कॉन्ट्रैक्ट्स आर एनफोर्सेबल बाय लॉ. यहां पे लॉ हमें परमिशन देता है सो दैट वी कैन मूव इनटू दैट, एंड दैट डजंट कंटेन एनी अनलॉफुल एक्टिविटी और एनी illegal object. So in this particular slide, what we have discussed the meaning of this particular topic, and that is legality of the objects. And on the other hand, we had a discussion regarding अगर हम बात कर रहे हैं illegality की, then what are the legal objects? So if you are coming for the sale of any goods or services as per the accordance of the law, then that makes a sense, that makes a legal sense, which also leads to enforceability and a valid contract. Let us understand the next slide. What are the essentials required to form a legality of the objects? किसी भी कॉन्ट्रैक्ट में मूव करने के लिए दी ऑब्जेक्ट, लॉफुल ऑब्जेक्ट होना बहुत जरूरी है. अनलॉफुल ऑब्जेक्ट्स अगर होंगे तो वो कॉन्ट्रैक्ट ही नहीं कहलाएगा, बिकॉज उसकी हमें कानून, हमारा भारतीय कानून इजाजत ही नहीं देता है. सो लेट अस अंडरस्टैंड व्हाट आर द एसेंशियल्स रिक्वायर्ड टू फॉर्म अ लीगैलिटी ऑफ ऑब्जेक्ट्स. नंबर 1, लीगैलिटी. The contract should contain some legal objects. जैसा मैंने आपको बताया, ड्रग ट्रैफिकिंग नहीं होना चाहिए, कोई भी माल प्रैक्टिसेस नहीं होना चाहिए जो कि इलीगल हो. तो अगर कोई इलीगल ऑब्जेक्ट अगर आपके कॉन्ट्रैक्ट में आ रहा है, दैट विल नॉट फॉर्म अ वैलिड कॉन्ट्रैक्ट. नंबर 2, कंसिस्टेंसी विद पब्लिक पॉलिसी. The object should be aligned with the societal norms and public interest. जो भी आप ऑब्जेक्ट्स क्रिएट कर रहे हैं अपने कॉन्ट्रैक्ट में, that should definitely benefit to the societies and to the public also. In order to get legality of the objects, this particular point is also very important. Number 3rd point is certainty. The object of the contract should be clear. Whatever the terms and conditions are there in a contract, the object of the contract should be clear, specific and definite. If it is not clear, if it is not communicated properly, अगर हमें पता ही नहीं होगा, contracting parties को पता ही नहीं होगा कि legality क्या है अपने object की, तो how will they appear into that particular contract? तो वो कर ही नहीं पाएंगे, and they'll not show that those intentions to form a contract. So in order to have legality of objects, this is very important, and that is certainty. It means your contract should be clear. I mean, the object of the contract should be clear, it should be specific, and it should be definite. What is the next point? Possibility of performance. The object should contain the possibility of its performance. Whatever the object you are setting to form a contract, that should have the possibility to perform. आपने एक ऐसा टास्क सामने रख दिया कि जो परफॉर्म ही नहीं किया जा सकता, तो वो कहीं ना कहीं एक अनलॉफुल टास्क ही कहलाएगा. वो एक ऐसा टास्क कहलाएगा जो कि परफॉर्म नहीं किया जा सकता, और अगर वो परफॉर्म नहीं किया जा सकता, दैट विल डेफिनेटली नॉट फॉर्म अ लीगैलिटी ऑफ दैट ऑब्जेक्ट. सो कहीं ना कहीं पॉसिबिलिटी ऑफ दैट पर्टिकुलर परफॉर्मेंस इज वेरी इंपॉर्टेंट. व्हाट इज द लास्ट वन? म्यूचुअल एसेंट, जिसको जस्ट अभी हम लोगों ने लास्ट वीडियो में पढ़ा. Mutual assent, both the parties should have free consent with the same intentions. Whosoever is coming to a contract, whosoever the party or the another party is coming to a contract, they always should have mutual assent or mutual consent, or you can say free consent between the contract, between the parties. I hope this particular slide is clear to you. So what we have discussed in this slide we have talked about the essentials of a legality of the objects. The number one is legality, the number second is consistency, which means the object should be aligned with the society and the public norms, public interest. Number third point is certainty. Whatever the object you are taking in to form a valid contract, that should be clear, specific and definite. And what is the next point? Possibility of the performance. Definitely, whatever the task, whatever the object you are setting to form a valid contract, that should have a possibility to perform. And the next point is free consent, which is absolutely very important. Let us move to the next slide to make it more clear. Now, the next point is capacity. The contracting party should have legal capacity. If you remember the last videos of this particular subject, we had a discussion regarding the legal capacity of the people. Agar do insan, if the contracting parties don't have legal capacity, then they may not be able to form the legality of the objects, and that will lead to the void contracts. Next point is free consent, which has already been discussed. Next point is intentions to create a legal relations. The parties, the contracting parties, the person, those who have come into an offer and acceptance, they must intend to form a legal contract. Agar unka legal contract nahi hai, agar koi bhi legal object nahi hai, then that would not form a legality of the object. The next point is, not the least point, not illegal or immoral. The object should not involve any illegal or any unlawful activity, which we have already been discussed in the last slides. So what we have studied in these slides: number one, capacity; number two, free consent; number three, intentions to create relations, legal relations, positive relations, relations with the same intentions, etc. And next point is, not illegal or any kind of immoral activity should be there to form a valid contract. I hope this slide is clear to you. Let us move to the next slide. So now this is the answer time to the question. The question which has been asked by me to you to create an excitement related to the subject. The question is, you have to identify the essential requirement to form a valid consideration in a valid contract. The four options are: equal value between the parties. Do you feel that is it the correct answer? The second point is performance of an existing legal duty. The third one is consideration given after the contract is formed. Or number fourth point is consideration that is illegal in nature. So the correct answer is performance of an existing legal duty performs as an essential requirement to form a valid consideration in a valid contract. So here we come to the end of this video lecture. So in this particular video we have discussed about the new topic, another topic, and that was consideration, and the another topic was legality of objects. In consideration, we also have we also had a discussion regarding the essentials required to form a valid consideration. You better understand what is consideration now. Consideration means something which should be exchanged between two contracting parties. And the next topic was legality of objects, which means there should not be any unlawful object to form a valid contract, because किसी भी valid contract को form करने के लिए एक भी कोई भी lawful object काम नहीं करता है. So in order to form a valid contract, the legality of objects should be there between the contracting parties and essentials to form a valid consideration. So I hope आप लोगों को ये वीडियो अच्छी लगी हो. I request you to please stay connected with us. S. Chand is always there to help you.
If you want to study this topic in detail, refer to the book by S. Chand Publishing and Vikas Publishing House. Link is provided in the description box. If you found our video interesting, please like, share and subscribe. And do not forget to press the bell icon.
All rights reserved. This video has been prepared for educational purposes only. No part of it may be reproduced or copied without the permission of the copyright holder.